Good day, everyone. So now we are going to tackle our group reporting entitled Citizenship Article 4. So now let's proceed.
Good day, everyone. My name is Reverend Lawrence Rico, and I'm here to present the definition of citizenship. Citizenship is the legal status and relationship between an individual and a nation. It means being a recognized member by this. It means a recognized member of the state and the nation, with certain rights, duties, and responsibilities. Let's move to the citizens' rights, duties, and responsibilities. Citizens usually have rights such as the right to vote in election, the right to work and live in the country, the right for education and healthcare, the right for protection under the law. Despite having rights, they also have duties and responsibilities such as obeying the law, paying taxes, respecting people's rights, and participating in civic life such as community service and etc. Now let's move to the four types of citizenship. Citizenship have four types. First is citizenship by birth. Citizenship by birth means a person becomes a citizen because they were born in that country. For example, a baby born in the Philippines, that child become a Filipino citizen because they were born in the Philippines. Next is citizenship by descent. This person becomes a citizen because their parents are citizens of that country even if they were born somewhere else. For example, if a Filipino couple has a baby while living in Japan, they are still a Filipino citizens because the parents are Filipinos. Next is citizenship by naturalization. This happens when a foreigner applies and is granted citizenship after living in a country for a certain period and meeting legal requirements. For example, a man from Korea who has lived in the Philippines for many years follows the laws and applies to become a Filipino can gain Filipino citizenship through naturalization. Next is citizenship by marriage or registration. A person can also become a citizen through marriage or by registrating under the special laws. For example, if a foreign woman marries a Filipino man, she may apply to become a Filipino citizen through this process.
A pleasant morning, afternoon, and evening to everyone who is watching this right now. Hi, my name is JB, and today I'm going to discuss about the difference between nationality and citizenship, use solely and use sanguinis, and case analysis of citizenship. Now let's start. What is the difference between nationality and citizenship? When we say nationality, it is uninherited, often international identity tied to the country of one's birth or parentage, while citizenship is a legal status conferred by a state that grants specific rights and duties within the country's political system. So basically, when we say nationality, it is who you are by birth or family. While when we say citizenship, it is your legal connection and duties to a country. So that's the difference. There you have it. The difference between nationality and citizenship. Now let's move on to use soli and use sanguinis. When we say use soli, it is the Latin term for right of soil, which is a legal principle that grants a person nationality or citizenship based on their place of birth. This means a child born within the territory of a country automatically becomes a citizen, regardless of their parents' nationality. It is also known as birthright citizenship, and it's common rule in many countries like in America. So when we say birthright citizenship, it is a legal right to citizenship for all children born in country's territory regardless of parentage. Okay, now, what is jus sanguinis? When we say jus sanguinis, it is a legal principle where national nationality is determined by the nationality of one's parents, translated as right of blood. This means a child's citizenship is based on parents or nationality regardless of where the child is born. So it's also known as parental citizenship. It is a child becomes a national if one or both parents are citizens of that country. That is jus soli ed jus sanguinis. Okay, now let's talk about the case analysis involving citizenship. So here we have Tancho versus Secretary of Labor. General Republic number 47616 affirmed that a person born in the Philippines of a Chinese father and Filipino mother is a citizen of the Philippines by birth. We also have Lamsang versus Common of Philippines, General Republic number 47623. Dismiss a naturalization petition because the applicant born in the Philippines to a Chinese father and Filipino mother was already a Filipino citizen by birth and did not need to be naturalized. We also have Paul Lamanzares versus Commission on Election, General Republic number 221697 slash 221698 700. Address the definition of natural born citizen under the 1987 Constitution.
So, I'd like to discuss the citizenship in the Philippines. The Philippines has three important rules in 1935, 1973, and lastly the 1987. These rules help decide who is a Filipino citizen. How citizenship rules change. According to the old 1935 rule, before all fathers could make their children Filipino citizens. If a mother was Filipino and the father was from another country, their children had to stay Filipino when they grew up. So, these are the rules in 1935, which is the old rules. So, the first one is that only fathers could make their children Filipino citizens. So, the second one is children of Filipinos and foreign fathers had to choose to be Filipino when they grow up. So, the last one is women married foreigners lost their Filipino citizenship. Based on the 1973 rule, which is the old rule. This rule made things fair. It said that both mothers and fathers gave their children Filipino citizens. So, these are the rules in 1973. The first is mother and fathers can now make their children Filipino citizens. Second one is children born before 1973 to be Filipino can choose to be Filipino citizen as adult. Third one is women who marry foreigners keep their Filipino citizens unless they give it up. So, according to the 1987 rule, now, this is the current rule. It says that if one parent is Filipino, their child is automatically a Filipino citizen. It also says that Filipino who marry foreigners, they lose their citizenship unless they want to give it up. So, these are the rules in 1987 or the current rules. So, the first one is mother and fathers can make their Filipino citizens. The second one is children are automatically Filipino citizens if one parent is Filipino. The last one is having two citizenship is not encouraged but it's allowed. So definitely in the summary, The changes in the rules have made citizenship fairer and clearer. Now, everyone has an equal chance to be a Filipino citizen. So, no matter how their parents are, this helps make sure that all Filipino citizens are treated equally and have the same opportunities. Thank you.
First, Birth Sanguinis, 1987 Constitution, Article 4. Citizenship is a at birth a person has at least one Filipino parent. This principle is known as a jus sanguinis or right of blood, meaning citizenship is determined by the nationality of the parent greater than the place of birth. Second, judicial naturalization, Commonwealth Act No. 473. This is a legal process where a foreigner can acquire Filipino citizenship by filing a petition in court. The court evaluates the petition and if approved, grants citizenship. This process involves meeting certain such as a residency, good moral characters, and allegiance to the Philippines. And third, administrative naturalization. Republic Act 9139. This would provide us a more stateless and simplified process. Native-born foreigner who's born in the Philippines but not citizens to acquire citizenship. It is an administrative procedure handled by government agencies rather than through the court. And fourth, derivative naturalization, Commonwealth Act No. 473. Citizenship is granted to the wife and minor children of a person who has naturalized as a Filipino citizen. The means that becomes a Filipino citizen with naturalization their appears and merchant can also automatically acquire citizenship. And pang-5, repatriation. Republic Act No. 8171. The mode allow for West Filipino citizens who lost their citizenship due to marriage to a foreigner or naturalization is another country to restore or regain the Filipino citizenship. It is a way the return to the citizenship. And panglas naman, dual citizenship. Republic Act No. 9225. This allowed the natural-born Filipinos who have become citizens of another country to return or acquire their Filipino citizenship. It recognized the possibility of holding citizenship in two countries, simulating mutually allow Filipinos abroad to enjoy rights and privilege in Philippines without resourcing their foreigner citizenship. So, nakasama rin naman ba, citizenship the Philippines can be acquired by through legal process involving court or administrative agencies by the derivation through family relationship or by restoring citizenship. This road provides action, the law, and mechanism to accommodate various circumstances, include dual citizenship for Filipino living abroad.
So let's talk about the citizenship for child. Under Article 4, Section 1 ng 1987 Constitution ng Pilipinas, pagkamamamayan ay maaaring makuha mula sa alinmang gulang ang mga ina. Ibig sabihin nito, isang bata ay tuturing na Pilipino kung sa kanyang magulang ay Pilipino. Sa kaso ng mga anak sa labas, ang patakaran ay magkaiba-iba depende kung sino sa mga magulang Pilipino. Kung ay Pilipino, ang anak sa labas ay otomatikong Pilipino dahil malinaw na pinapayagan ng batas na sundan ang pagkamamamayan ng ina. Ano man ang kanyang pagiging limo. Gayunpaman, kung ang ama ay Pilipino at ang bata ay sa labas, ang bata ay hindi otomatikong nagiging Pilipino maliban kung formal na kilalanin ng ama ang bata, alinsunod sa batas. Tulad ng pamamagitan ng sertipiko ng kapanganakan o birth certificate, official dokumento. Sa makatuwid sa ilalim ng Article 4, ang pagkamamamayan isang anak ilabas na nakasaalay sa pagkamagulang ng Pilipino at sa mga legal na pagkilala ng isang relasyon. Sinasabi lang po dito na kung ang anak po ay isang Pilipino, nagiging automatic na Pilipino rin po ang isang bata, lalo na kung ito po ay anak sa labas. Pero kung ang tatay man po ay isang Pilipino at may anak ito sa labas, kakailanganin pa po ng mga espesyal na dokumento na makilala pa niya ang kanyang anak or kikilalanin pa ang kanyang anak upang maging Filipino na rin ang bata. Thank you!
Ang part ay pe-present ako naman po ay ang naturalization citizenship. Ano nga po ba ang naturalization citizenship? Ang naturalization ay proseso kung saan ang isang dayuhan ay opisyal nagiging citizen ng Pilipinas. Para maging citizen, kailangan niyang patunayan na may good moral character siya, matagal na siyang nakatira dito, marunong sa ating wika, handang sundin at mahalin ang kultura at batas ng bansa.
Good day everyone. Today I'm going to talk about dual citizenship. It's important because it helps us understand how a person can belong to both countries at the same time and what rights and responsibilities come with. Dual citizenship means being a citizen of two countries at the same time. It happens because a person is recognized by both nations as their citizens. For example po, some born in US to Filipinos can be both American and Filipinos. It's good because you can live, work, and both in both countries, and you have more opportunities and freedom. But it also means you must follow the laws and duties of both nations. Dual citizenship is important because it connects people to vote their roots and future of the people.
Good day everyone, my name is Bonaventure Irish, and now I will discuss the requirements for applying citizenship, whether you want or not. The requirements in naturalization are age, residency, moral characters, language, knowing of Philippine history and culture, and lastly is financial capacity. And the documents are birth certificate, marriage certificate, police clearance and NBI clearance, barangay clearance, proof of financial capacity, affidavits of witnesses. So let's now proceed to dual citizenship. The requirements are natural born Filipino citizenship, second is requirement, third is foreign citizenship. So the documents are application form, birth certificate, naturalization certificate, PH and foreign passports, that is Philippine and foreign passport, photographs for change name and payment. That's all.
Those were indeed mouthful of words, but don't worry, we're going to dig deeper about this case analysis. First, let's start with Tan Chong and Lam Swee Sam. Both were born in the Philippines to Chinese fathers and Filipino mothers. They both claimed they were Filipino citizens by birth because they were born here. First, the Supreme Court agreed and said they were Filipinos. But later, the Solicitor General asked for reconsideration arguing that the laws at the time of their birth didn't give citizenship based on their birthplace, which is jus soli, but on the citizenship of the parents, which is jus sanguinis. After reviewing the case, the Supreme Court changed its earlier decision and ruled that the Philippine law before 1935 did not follow jus soli, citizenship by place of birth. Only those whose parents were Spanish subjects during the change of sovereignty after 1899 were considered citizens. Since Tanchong and Suisang had Chinese fathers, they inherited their father's citizenship and were not Filipinos by birth. The court also said that jus soli, citizenship by birthplace, doesn't apply in the Philippines because it was never officially extended here by U.S. law. Final decision of the court was Anchong is not a Filipino citizen, he must be treated as a Chinese national. While Lam Suisa is not a Filipino citizen either, but he can apply for naturalization under the existing law. Okay, so what is the law that says they are not Filipinos? It is the Article 4, Section 1, Paragraph 3. It says there that those whose fathers are citizens of the Philippines are citizens of the Philippines. So, in 1935, this was 1935 Constitution, not the 1937 Constitution. So, during this time, the only exception to this law was the Spanish subjects during the change of sovereignty because the Spanish colonizer ruled as Filipinos in 303 years. So there are a lot of Spanish nationals and half Spanish Filipinos during that time. And the time of birth of Jose Tanchong and Lam Suisang. Jose Tanchong born in July 1915 in San Pablo, Laguna. And Lam Suisang was born on May 8, 1900 in Holoslu. So the time of their birth was under in 1935 Constitution. So during that time, they are not considered as Filipinos. Okay, now let's move on to on March 8, 2016, Grace Poe Mary Grace Natividad S. Poe Lamanzares, petitioner, also known as Grace Poe, was a foundling, a baby found abandoned in Iloilo when she was just a few days old. No one knew who her real parents were. She was later adopted by Fernando Poe Jr. and Susan Roses, both famous Filipino actors. When she grew up, Grace Poe studied and lived in the U.S. and became a U.S. citizen for a time. Later, she returned to the Philippines, gave up her U.S. citizenship, and ran for public office. In 2016, she decided to run for president of the Philippines. Then, when she decided to run for president, people said that Grace Poe cannot run for president because she's not a natural-born Filipino citizen. Because the people don't even know who her real parents are. Okay, under the 1987 Constitution, a presidential candidate must be a natural-born citizen and a resident of the Philippines for at least 10 years. So the COMELEC or the Commission on Election disqualified her, saying, "You are not proven to be a natural-born Filipino." So Grace Poe then appealed to the Supreme Court. When Grace Poe appealed to the Supreme Court, they asked her if Grace po is a natural-born Filipino citizen even though she's a foundling or the child of unknown parents. So the Supreme Court said yes, Grace po is a natural-born Filipino citizen and can run for president. Why? Because foundlings are presumed to be citizens of the country where they are found. She was found in Iloilo, Philippines, so she's assumed as Filipino. To say otherwise would make foundling stateless. That means they wouldn't belong to any country, which is unfair and against to our human rights. The Constitution protects children and equality. Foundlings deserve the same rights as other Filipinos. She didn't have to do anything to become Filipino. So she's natural born citizen from birth, no need for natural. She met the residency and requirement. So totality, Grace po is Filipino. So you have it, the differences between nationality and citizenship, jus soli and jus sanguinis, and the case analysis of citizenship. Thank you. Bye.